Welcome to The Launch, the podcast sponsored by TandemLaunch, where we talk about tech, startups, entrepreneurship, and everything in between. We give you the inside scoop on building a startup, capital fundraising, the entrepreneurial journey, with both funny and impactful stories. This podcast is for budding entrepreneurs, ecosystem players, industry folks, venture capitalists looking for deals, students considering a career in the startup world, or anyone with a curiosity in deep tech. If you have a research background in tech and always wanted to build your own startup, then check out our website, www.tandemlaunch.com, or hit us up on LinkedIn. Let's build the future together. And now, on with the show. Welcome, everyone, to another episode of The Launch podcast, sponsored by TandemLaunch. I'm Bobbi Bidochka, your host, and today joining me is partner and patent agent from BCF, Julien Lacheré.
Hi, Bobbi. Really nice meeting you. Really nice being with you guys today. I guess we'll be talking about IP, tech, and patent, and any other topics that you may find relevant, yes. Bobbi.
How all those things go together. Thank you so much for being here. So let's jump right into it. So who are you, Julien? And maybe just tell us a bit about you and BCF.
Yeah, sure. Not that I usually like to talk about me, but I'll start with me, which probably is more interesting than telling the story of a law firm. Believe it or not, I'm a software engineer by training. I ended up doing a master of research in data sciences, but that was 15 years ago. And at the time, the field was much less trendy as it is today. So I was struggling whether or not I should go for a PhD and becoming a professor. Did not really feel like it. And I've turned to something that could use engineering and that was more connected to the business. And I ended up discovering almost randomly patent law and IP law. And I started my career in that field right after engineering. I worked for a big corporation in the aerospace industry. I worked for a Canadian law firm. And in 2014, I've joined BCF and I've been there since then. And I think one personal struggle that I had was to try to find out a path that mix engineering, patent law, and entrepreneurship. And I ended up, after starting my career, mostly working for a big corporation and multinational, I figured that maybe the skills that I've learned and developed could also be useful to young, emerging tech startup companies. And we can go back to it, but while I was working in an aerospace company, I've helped at night a friend of mine who was starting his startup in the fintech domain. And essentially, the company was developing solution to turn an iPhone into a payment terminal. And at the time, as I was back in 2011, no one has thought about turning the iPhone or your Samsung device into a payment terminal, meaning that it's not about emulating the credit card. It's about emulating the terminal so that you would get rid of those terminals that cost a fortune to basically company charge you $70 a month and they take 2 or 3% as a fee for each transaction. So what we've done on the IP front at the time is we've tried to map out what the Visa, MasterCard, Ingenico of this world were doing in terms of patenting. And we've also looked at what Apple and Samsung was doing in that particular field. And back in 2011, the big push was about what became Apple Pay or Samsung Pay, essentially emulating a credit card with your iPhone. And no one really investigated the idea of turning the phone into the terminal itself. So we saw two opportunities here for this venture. First, they could start building and grow a technology in a field where there is no competition yet and less risk of building upon an existing patent. So the last thing you want to do is to build a company on a patenting feature patented by, let's say, Google or Apple. That's not a great start. So that's one way to salvage that risk, is like positioning your tech in a white space. And that also gives you another opportunity, which is to get your own patent on it. So fast forward 9 years, and that company got acquired last year by Apple. And meanwhile, we've built like a portfolio from like an early cheap provisional application up to close to 10 patent family filed in multiple countries. So like there's this whole journey about like going from the idea in the garage up to like the acquisition made me realize that maybe I do have a skills that could be useful if used wisely with the right people. So that's in a big, long nutshell what I do, who I am.
Great. And so how does BCF work in these terms?
Yeah. Okay. So BCF, the reason, to be honest with you, when I back in 2014, while I was still working for this big aerospace company, I thought that either I could jump and join a startup or start a patent practice geared toward startup companies. And I honestly was not even considering going back to private practice in a big law firm. And the reason why I joined BCF was because some of my former colleagues were there and they were very convincing. But for two reasons. First, I think BCF has an interesting DNA, still a relatively young firm. They've been created 25 years ago. They really started as a little shop, and they've managed to grow with some of their client. Now we're close to 500 employees, and I think they still have this entrepreneurial DNA, which I kind of relate to. And also, they allowed me to invest in developing a practice more geared toward early stage companies.
Great.
So,
And so, yeah, how do you work with tech startups in particular?
so I really from the inception of the company up to, I would say, becoming a multinational organization. But I think what I find the more appealing and rewarding for us, either as tech lawyer or IP practitioner, is to be onboarded in the early days and really follow the growth of the companies. And it's a bumpy, usually a very bumpy path. and I think the way I started to look at it is pretty much in the eye of an investor. And instead of investing my money, I invest time. And how do we build a pipeline of clients which are likely to succeed ultimately? Because we're a law firm, like obviously we have some financial constraints, and it's okay to fail sometimes, but if you fail too many times, it's like ask a VC if they fail too many times, what happens? Just pretty much the same for a partner in a law firm, especially when you deal with early stage venture, there's a certain amount of risk. You need to be able to deal with that risk and try to optimize your chance of return, of having a return on investment. So the idea is when we onboard is to try to define a framework in which we limit the cost and the financial burden to the company, and eventually try to ramp them up in a way that once they're well funded, they can afford our regular fees essentially.
Mm-hmm, mm-hmm. Okay, great. And that sounds very startup friendly. That's for sure. So then what are the most common mistakes do you think that, surrounding entrepreneurs and startups with doing their patents?
Okay, so if I step back for a moment, and I know that your guys and your entrepreneurs are already pretty savvy on the topic of IP and patents, but if I step back, I think you need to look at the foundation. When you start a tech venture, it's all about the IP essentially. What I call the intellectual assets. So to me, the definition of intellectual assets, it's a combination of your talent, so the quality of the team, the quality of your brain, associated with the legal tools that will allow you to capture and monetize your creations. And patents are one form of IP. Typically, when you're a tech venture, you're mostly dealing with three main buckets, I would say: patent, copyright, especially when you do software, and trade secrets. And there's always a balance to be struck between those three forms of protection, and always need to think about how, okay, what do we keep trade secret? What do we try to patent protect? And the mistake that I see quite often, there are many. I think the first one, the easy one, is like they simply brush the IP topic or the patent topic aside under the carpet and say, well, we'll deal with it later. And this is problematic in many ways. Maybe not at the beginning. I think up until you start like raising some serious money, you may manage to, escape. But at some point, if your intent is to build a world-class organization, which will be able to attract the key talents and big money and eventually be acquired, you need from the get-go, you need to take the topic of IP very seriously and bake it into your DNA. So yeah, one mistake that I see is that like people just like don't address the issue at all. The other extreme is that they go too fast, too quickly. The venture is still in its early days. They just have a general idea of what the product might look like, and like they rush to file a bunch of patent application, spend a big chunk of money, and then forget about it for years because like, oh, we've checked that box. We're good to go on the patent side. And I don't think this is the appropriate approach. I think it's like many things upon growing a successful company. It's about planning for the long term and articulating a reasoning as to why you do certain things. And it might be fine to file a provisional or two at the beginning just to capture like the big general concept. But I think the value comes later. And you don't work with your patent agent just to get a patent application file and then you move on with your life. I think the idea is really to find a partnership, a collaboration, which will allow you to grow an IP portfolio as you grow the technology, as you grow the company. So yeah, so on the other extreme, I say don't spend too much money too early on patent. Focus on positioning the company at the right spot. Make sure you are addressing a difficult problem that is for which the solution is scalable and address an actual need. Raise the money, go get the key talent. And once you have all those ingredients, then you will start growing a portfolio. Like the patent portfolio to me is like the icing on top of the cake, but you need to first focus on the cake itself.
Right. Yes. Well, I mean, I guess that's why having good friends like you is important so that they know what to do and when. So there's a lot of talk, these days about open innovation and versus like patenting and how that affects the research process. And I remember when I was at McGill, it's always like, oh, do you think you have something? Well, go to the tech transfer office and like, fill out some forms. They're like, so it was like I had to push them, go talk to somebody about patents. So why do we need to file patents anyways?
A very good question. Well, I need to pay my mortgage. That's one answer. But that's probably not the one you want or need to answer. I think you first need to understand why you think you need to go for patent protection. Those things are costly, and if you want to run a business, you make decision based on the return on investment. So you need to think, okay, why do I need to patent this, and at what point of time? And going back to the tech transfer offices, to me, it's really about like the whole process of innovation, of going from a scientific discovery to a technology to a product. And I think along that chain, there are various IP strategies depending on whether you're the university or you're the entrepreneur or the acquirer. And yeah, I've seen. I mean, I think Google is a good example. I think the key technology, the fundamental technology, was created while Sergey Brin and Page were still at Stanford, and the original patent got filed by Stanford, and I think licensed or transferred then to Google. So this situation may arise, but I don't think you necessarily need to start from a patented technology to start a venture. I think it's really about focusing on addressing the right problem. And then eventually you will come up with some valuable piece of solution that in themselves will be patented.
Okay, so just get into a little bit more like concrete terms, like for those who are at this point, when is a good time to start thinking about patenting? Like what's the step-by-step 1, 2, 3?
Okay. So you need to start thinking about it right now. Like before you even start the company, you need to deal with your IP and make sure you have a clean house, meaning that first you own what you're supposed to own. That it starts with simple thing as employment agreement with your contractor and developers, making sure that whatever is being created is owned by the corporation.
Oh, so that should be embedded in every contract. Oh, okay, good.
Yeah. That's the foundation. That's the number one, because ultimately, if you want to patent something, you first need to own it. Otherwise, you're going to spend money patenting something that is owned by someone else. So that's the first thing. Then after comes I think the ongoing decision process as to whether or not you should go for patent protection. And the usual trade-off is like either you keep it a secret and you derive your competitive advantage by maintaining your creation secret, or you do the opposite. You go for patent protection. Patent protection, it's about I will disclose the invention in the patent application, in exchange of which the state will grant me a monopoly for 20 years on a certain piece. I see a patent as let's say a piece of property on a land. It's a virtual land. It's a virtual technological land. So I think every step of the way, you need to ask yourself whether that land is or will have some value eventually. And this should drive the decision as to whether or not you go for patent protection. As to when you should consider patenting, it's always a difficult decision process, because in order to be patentable, your invention needs to be novel. Novel means that it has not been publicly disclosed by anyone, including yourself. So if you consider releasing, for example, your MVP to people that are not under an NDA, what you've just done is essentially create your own disclosure. And for many countries in the world, this is what we call a bar to patentability. If I disclose my invention today and I haven't filed a patent application, then I lost my rights essentially in many countries such as China and Europe. In the US and in Canada, there is provision to the effect that you still have 1 year from the public disclosure to be able to validly file for your patent application. So you need to consider that as a bar date. The other thing you need to consider is competition, because if you're working on something which is valuable, chances are that someone else in the world is also trying to address the same problem, and they may come up with a similar solution. And if they do eat the patent office before you, then you're kind of stuck, because they will own the patent, even so you've created on your own without them the invention, they will still be in a position where they can block you to the market, essentially.
Mm. That's a bummer. Let's try to avoid that, people. Try to avoid that. And so, I mean, startups in the beginning, they have no money. Which
Yes.
is probably the biggest reason why they don't. I'm not sure that it's not that they're not thinking about it. It's that they can't do much about it without having a little bit of cash. And I mean, I do see some people like stealth mode, in what they're doing, but I don't know. It's pretty hard to build a startup in secret when
Yes.
you need so many people to help you. So what's all involved, like cost wise?
Okay. Well, it's a very good question, because patents are not cheap. They are expensive. Like the cost of obtaining a US patent and maintaining a patent for in the US for 20 years is roughly $50,000. So it's a huge amount of money. Wow. But the good news is that you don't have to pay that money upfront.
Oh.
You can start with you can spread the cost over like the 20 years of the patent. And usually the process starts with filing what we call a provisional patent application. So those things are not that expensive. you can either have your patent agent like me do it for you, or you can work closely with the patent agent to do most of the work yourself. And that's what I like to do when I start working with a very early stage venture where money is tight, but I'm convinced that they will go somewhere and that they're onto something big. So I personally rather that they keep their money and do the work themselves. So what you can do is a provisional patent application. It's all about describing your invention and also describing how your invention could be implemented by others. So, and it's more of a technical exercise where your engineers will have to explain and describe in plain English with drawings what the invention is about, how it works, how it could work. And ideally, if you really want to be, use the system to your advantage, is that you try to anticipate the various directions that the technology could go. And especially when you're in the early days, you are very likely to pivot a few times. So what you want to avoid is to file a patent application on something that will be irrelevant 2-3 years from now. So you need to anticipate and start to, read through the crystal balls and come up with all those ideas and document that into the provisional application. The provisional application, if you do most of the work and you just have like a professional like me review your work, you could get it filed for, let's say, $3,000 to $5,000. That will secure you a priority date. And then from that date, you'll have a year to decide what you want to do with it. And you can file it as a national regular application, or you can file it as what we call an international PCT application. PCT application, it's a pretty cool tool because instead of having to file, let's say, in 5 or 6 countries, which will cost you a fortune, you say, I'm just going to file a single international application, which is going to cost me $5,000 to $6,000 in terms of governmental fees and filing fees. You need to add like the work with your patent agent. But essentially, it will secure your application at the international level, buying you an extra year and a half before deciding in which countries you will go. So if I go back with what I just said, you start with a provisional application, let's say 3,000 to 5,000. A year after you file your PCT application, 5,000 to 6,000 in filing fees, plus the time you will spend with your patent agent. That's where it can add up to $8,000 to $10,000 for complex technologies. And then you're good to go for another 18 months. So 2 years and a half from the date of filing the provisional application. The idea is that within those 2 years and a half, you have enough time to start raising capital, to start validating your product, and be in a better position to support the financial cost associated with patenting the technology.
Gotcha. Okay. Whew. So yeah,
that's a lot of information.
Yeah, this is a lot of information. That's why we're going to try and throw some jokes in between. So, I think it can be exciting. It can be. So one thing that I noticed is, especially, in TandemLaunch, which is Canada's premier incubator, it's hard to find good software IP. And it's because I think it's hard to patent software. So can you talk to us a bit about that?
Great question. I think we could go on for an hour just on that topic, but it's a moving target about that. There used to be a time up until 2012 where pretty much anything under the sun could be patented in the US. So that led to like crazy things such as like patents on a method for training a cat, or a method for hedging financial risk between financial institutions, and so on. So the US scaled back a little through various change in the law, the American Invent Act of 2013, and a key Supreme Court decision called Alice, where essentially they've said, okay, we cannot grant you a monopoly, a patent on what we call an abstract idea. We can grant you a patent essentially on a technical solution to a technical problem. So when I translate this like key legal principle to software, you end up in a situation where like the general idea, the general concept is what we call an abstract idea that in itself cannot be patented. But when you start drilling down as to how you implement that general idea, usually you happen to solve technical problem and come up with technical solutions. And you look at the Uber patent portfolio, for example, they did not manage to obtain a patent on the general concept of putting in contact a driver and a passenger. What they've built instead is a patent portfolio targeting technologies enabling this platform to operate and exist. So they have a bunch of patents on like geolocalization, optimization of routes, pricing, and so on. So all those pieces that are software implemented are patentable, providing that they are novel and inventive, which are the key legal criteria for patentability.
Right. Okay. And then because these things can be so, because once you patent, that means that people have access, to the details of, because that's the other side of the downside or the upside.
That's the trade-off.
That's the trade-off. And then so people can go look at that. Oh, I'm going to modify that just enough. This is the problem with patenting algorithms, right?
And that's part of the decision process. And I think that's where like the professional with who you're going to work, I think his main role should not be to file patent application and charge you for a patent. I think the value is more on the advising, on helping you making the right decision before you spend the money. And when it comes to like patentability of software, the most challenging part is about extracting what is the invention, because like throwing me 10,000 lines of code is not going to help. We need to work out together to be able to say, okay, this is what the novelty aspect, like the core of what we believe we've invented. And we need to extract that usually through what we call an invention mining session. And we need to bear in mind that that thing needs to be novel to be patentable. So usually we start with the inventors themselves because they are the one who've created the algorithm, let's say, and they are the one who tends to know the state of the art. But usually we recommend to do also a top-up prior art search that they can do themselves, like with tools like Google and Google Patent, or that we can do with our professional searcher. And the idea here is to assess the novelty of what they believe they've created. And very often they think they've invented this, and you do a search and you realize that indeed the novelty features are just that. And at that point of time, you need to make a business decision. You need to decide whether or not it is worthwhile to invest the money in trying to get a monopoly on this. Because if this is very narrow, it means that my competitor, if they have 10 other ways to implement, they'll go for a design around. So the value of my patent will be very limited. So I would say you need to, you invest if I think you come up with something great and novel, and which is likely to become a broad enough patent to, become a valuable piece of virtual land, so to speak.
Yes. Yeah. The value there, I think that's the key. And so I remember again, when I was at McGill, just to slam them a few more times. They're a great university. Love them. Sometimes everyone thought they had something, and then, they get there like, this is not novel. You thought you did something great and you didn't. So what happens when that happens to you? And how do you very nicely tell them?
Don't be discouraged, because it happens 99% of the case, especially when we start working together in an early stage venture. Things, they come up with something great and you start digging and you find out that someone else in China have already investigated the field. And I said, look, it's not so much about the solution. Don't focus so much about the product. I think to me, it's about finding the right problem to solve, because that's what's going to keep you busy for the years to come. And by really focusing on this, on the right problem, you will create stuff, you will invent, and you will crack nuts, providing you have the right team members, but you will get there. And this will lead to valuable, patentable invention eventually. So don't be discouraged.
This is it's a startup mantra around TandemLaunch. Fall in love with the problem, not the solution.
Yeah, I love that. Yeah,
so what is the risk in working on a project while you're still employed? So, because there could be a conflict of interest, depending on what you've done, probably more than anything.
Yeah, it's a situation that we tend to see a lot because I mean we're in a small ecosystem, and very oftentimes people start working on their ID and their company while they're still employed by their current employer. And more often than not, we need to, well, not sometimes we need to inform them that because of their employment contract, they have an obligation to transfer all of their IP and their creation to their current employer. So you need to be very careful if you start working on a new concept, on a new venture, while
Even if it's
still
in your
being
garage.
employed. Even if it's in your garage, as long as it's close enough from a technical standpoint from what you're being employed for. So let's say I work for an aerospace company and in my garage, I come up with an improvement for sorry, I have the word in French, une tondeuse, a lawnmower.
Okay, yeah.
I may have an argument to the fact that this is totally unrelated to my employment, and therefore the aerospace company has no claim over my creation.
Right.
But very oftentimes, like you're gonna start a venture because you know what, it's close enough from your field of expertise and experience.
Yeah.
And that's where it gets tricky and dangerous because whatever you create or even you file as a patent application at that point of time will likely be owned by your current employer. So you really have to cut that line and start working on your concept and your technology once you are no longer in that contractual relationship with your employer.
Okay. Yeah, and especially like a lot of employment contracts have a clause, even though they don't tend to exercise it often, like this is must be your only employment and you can't have another job at the same time kind of thing, which I mean a lot of people have another part-time job. That I don't think that's the issue. But when it comes down to that, that's where that contract can really, ooh dear. I did not know that. So that is good to know. World, listen up.
And as you said, they tend not to enforce, but I can guarantee you that if you come up with something extremely valuable,
Oh yeah,
they will enforce.
Knock, definitely.
Yeah. I think there's a famous recent case. It's the Waymo case. So a bunch of engineers from Google working on autonomous vehicle technology left Google and started a company called Waymo. They've raised money, they've built their tech, they got acquired by Uber. Transaction over $100 million. Google filed a claim against Uber for trade secret misappropriation and patent infringement. And they succeed. And they settle the case for a big chunk of money. Because some of the information and invention that were created while the employee were at Google leaked somehow in the new startup that they've created.
Well, I mean, they were all there, so it's in their heads, and then they went over here and took what was in their heads and put it out here. So,
and that's where it gets very tricky it's very tricky to draw a clear line between what is owned by your former employer and what is yours. But at the very least, don't start filing a patent application while you're still employed at the other place.
Right. Okay. Yes. Words of wisdom there. So then aside from patents, what other IP rights can tech entrepreneurs take advantage of?
But when you're in tech, I think you really need to be comfortable with like three main buckets of IP rights. So patent and industrial design, trade secret, and copyrights. We talked a lot about like patents. Patents, if you go back a little, they will protect the inventive concept. Ideally, if it's well crafted, it will not be specific to a given implementation. So the idea is that you manage to obtain a monopoly on a broad concept, which could be implemented in multiple ways. That's the base case scenario. As I said, you also have pretty like the little brother or little sister of the patent is the industrial design in Canada, the design patent. Those are specific to protecting the way things look. For example, the way my iPhone, the design of the frame looks, but also the apps and the layout of the software. And you can look up Apple or Google design patents. It's very interesting to see how far they go in trying to protect the visual appearance of their stuff. So essentially, if you put some money in designing some improvement to the graphical user interface, you might consider a design patent as a way of protecting your innovation. So that's for the main bucket, patent and industrial design. The second one is a copyright. So copyright, broadly speaking, it covers like many creation of the mind, including artistic creation, but first and foremost, in your case, software. So the source code, the first form of IP that is associated to the code is the copyright. And the copyright will grant you the exclusivity of reproducing or redistributing the software, meaning that someone cannot just copy your source code and put it into their product or share it to the public without your prior consent. The beauty of copyright is that you don't need to do anything to benefit from it, meaning that you do not need to register your copyrights to have the right. You may do so in certain circumstances, typically before initiating litigation, but otherwise, the only thing you need to do is to have like good practice in your development team. Make sure you have the proper headers in the source code files, little c, identity of the owner of the rights of the corporation, and the year of creation. The copyright is key to the open source license. Like, I'm just opening a quick parenthesis here, but very often for software developer, at least at the time when I was a student in software engineering, I thought that, it's open source, it's open bar. I can do whatever I want with it. And this is very wrong because open source is tied to copyright. And when you include, like you start using, let's say, TensorFlow, which is the Google suite for machine learning, which is released under open source licenses, meaning that you can use it for free, but it comes with certain obligation, meaning that if you start making improvement or modification to it, you generally are under an obligation to publish those improvements under the same parameters and under the same rights. So this can be very dangerous if you start building your technology using open source modules without keeping track of the licenses that are associated with the modules and without understanding what are the consequences. Because you may end up thinking that you're building a proprietary technology that is yours, and then you find out during, let's say, an acquisition, the acquirer will scan your source code and identify something that should have been released under an open source license. And that means that what you thought was proprietary is indeed governed by an open source license, and you have to release it under the same terms. So that's something to watch out. And that's for copyright.
Yeah.
And just to finish on copyrights, it's free, so it's great, but it will limit your protection to the specific implementation of the code itself. Meaning that if you come up with this fantastic new algorithm and you code it into, let's say, Python, yes, your code will be protected by copyright, meaning that you would have a course of action if someone takes the code, copy it, and paste it in his own products. What you will not protect is the underlying logic of the algorithm. And that's where patent and copyright comes hand in hand together. Because with patents, you could protect the algorithm, like the more generic idea and concept, and the copyright will protect the specific implementation in a given code language. So that was for the second bucket. But I could fast track, but the last one is the trade secret, but I think it's an important piece into the equation as well. But so trade secret is essentially you build a competitive advantage by keeping your creation a secret. It's easy to say, it's very hard to implement. Because often case I see like startups, you do the due deal and they say, we don't file patent, or IP strategy is about trade secrets. And you say, yes, but you don't have any policy nor process in your corporation. That you're building this incredible stuff and all of your employee and consultant have access to it. So someone can leave the company and just restart another competitive company using the exact same principle. And yes, he may be in breach of agreement and you can go after him. But once a secret is leaked, it's like toothpaste out of the tube. You cannot put it back in.
Yeah.
So if you go, and it's a valuable form of protection, but you need to make sure you have the proper process and policy in place. You restrict access to the golden nuggets of your technology, and you do it only if you think that you could keep those nuggets secrets. Because if they end up being in the product or in the software that is licensed to someone else, then you're left with a patent as your only option for protection, because otherwise you just release publicly your technology with no rights associated to it.
Okay, yeah, so don't do that. Everybody, don't do that. Okay, great. So we're going to tie up this podcast. I'm starting to ask this question to everybody. So this is a random question. In the world of superpowers, so you can imagine all the superpowers out there. If you could have one superpower, which would it be and why?
Whoa, it's a question to me or to the audience?
You.
If I had a superpower, wow. Okay.
So mine is teleportation. I want to be able to go from A to B without traveling. I want to just boop, and then boop, I'm in China, or boop, I'm at work, like without the travel. Like it's a drag.
I'm more into time traveling. That would be a superpower that I would deem very cool. And especially for what we do, because that would give us a hint as to which direction we should be heading.
Or go back and get lottery numbers.
Yeah, but that's too easy. That's too easy. But at least just the general technological trend, because it's such a hustle to try to anticipate what's going to come next. Yeah. Because the reality, I think, no matter how smart you are, no matter how good you are or experienced you are, you're still dealing with a high level of uncertainty. So we think the big thing is going to be this, but turns out that the COVID vaccine will take over instead.
Okay, so crystal balls for Julien and for Chris.
Yes, that's a nice way to spin.
Perfect. Okay, so then tell everybody how they can get in touch with you, because indeed there's lots to learn and lots to know.
Thanks again for the opportunity, but I'll be more than happy to jump on a call or over coffee. That's what I like to do. So feel free to reach out at my email address, Julien Lacheré, julienlacheré.lacheré@bcf.ca. You can find my address on my webpage on the firm website. Or also, you can text me at 514-210-4883. I'll be glad to answer your questions.
Awesome. Giving out phone numbers. Love it. That's when you know I'm really serious. No, it means sometimes it happens. I am serious. Please get in touch with me.
And that's not a joke. I'm not giving you the number of one of my colleagues. That's my actual number.
That would be a good one. So thank you, Julien, again for joining us and jamming about IP.
Thanks again for the opportunity, and best of luck to the whole team. You're working on great stuff, guys. So keep going.
Thank you. Thank you so much. So thank you again also to our loyal listeners. Your time is always appreciated. You can follow us on social media, LinkedIn, Facebook, Instagram, and Twitter. And don't forget, if you have a technical background and you want to create your own startup, hit me up on LinkedIn and I can tell you about all the incredible opportunities at TandemLaunch. Ciao for now.
Thank you for listening. We hope you had fun and gained valuable insights. Why don't you subscribe to the Launch podcast today? You can share the podcast, tell a friend, and follow us on social media. If you have a research background in tech and always wanted to build your own startup, then check out our website, www.tandemlaunch.com, and get in touch today.